Good morning, I'm attorney Gary Finklea from the Finklea Law Firm in Florence, South Carolina. Today I'd like to address one question with you that recently arose in a case I had, and that is whether or not the Magistrate Court has jurisdiction in regard to an installment land sale contract. You would think the answer is simple, but in this recent case I was dealing with a very knowledgeable and wise attorney, and yet we had difficulty, or at least I had difficulty in convincing him that the Magistrate Court did not have jurisdiction, which that statement likely leads to the answer to my question, which in my opinion, the Magistrate Court does not have jurisdiction to evict a person who occupies a property under an installment land contract. Let me talk to you a little bit about the Magistrate Court's jurisdiction. First, in our South Carolina Code of Laws, specifically Section 22-3-10, the legislature codifies when magistrates have jurisdiction. And for purposes of the day, primarily dealing with civil issues. And the Magistrates Court generally has jurisdiction of most controversies between two people, a corporation, a person, or two corporations, in matters where the amount in controversy is less than $7,500. So generally, if the amount in controversy is less than $7,500, the Magistrates Court will have jurisdiction. The Magistrates Court does not have jurisdiction when a governmental entity is a party. I had a recent case where a local municipality sued a client of mine, and I was able to dismiss the case by way of motion. That lawyer, surprisingly, was not aware that the Magistrates Court did not have jurisdiction when governmental entities are involved. The second case is, of course, where the amount in controversy exceeds $7,500. And that can be the case whether or not the claim or the counterclaim exceeds $7,500. And one of the exceptions to when the Magistrates Court has jurisdiction is found, again, in our Code of Laws, and specifically at Section 22-3-20. And that code provision, in addition to dealing with the court has no jurisdiction when the governmental entity is involved, also deals with the exception when title to real property shall come into question, the court has no jurisdiction. So even though it's clearly stated, there still is some concern as to when the Magistrates Court has jurisdiction. But hopefully this segment will enlighten you on when the Magistrates Court does in fact have jurisdiction over central controversies. The Magistrates Court is generally a I don't know if more efficient is the right word, but generally you can get your case heard a little quicker, and it costs a lot less to have a controversy heard in Magistrates Court. In Magistrates Court, your right to a trial by jury is preserved. The primary difference is that the jury impaneled is of 6 of your peers, not 12, like in the Court of Common Pleas. If you have any questions concerning whether or not you should file your action in the Court of Common Pleas or Magistrates Court, please call me. Of course, in Magistrates Court, you generally find that individuals represent themselves more often than in the Court of Common Pleas. The rules are a lot simpler in Magistrates Court, and pro se parties can work their way through those and generally present a case fairly well in Magistrates Court. I would not suggest anyone to represent themselves in Magistrates Court, however, if the other side has an attorney, or of course it involves legal issues which the Magistrates Court may not be familiar with handling. But if we can help, please call us. You can reach me at 843-317-4900 or by email at gfinkley@finkleylaw.com or visit our website at finkleylaw.com. Thank you very much.